All right, so let's jump in. All right, so if you all will please look up at the monitors, you will see that this is the Spalding County State Court. My name is Josh Thacker, I'm the judge, and this is the bonded trials calendar call. I'm coming off the end of the cold, so I'm going to make sure to use this mic really well. If anybody can't hear me, let me know. All right, so I want to start out by saying that here in the Spalding County State Court, we believe that each of you, as you interact with this court, deserve the respect and the dignity that you would ask for someone you care about. We will extend that to each and every one of you as we interact with you all here today. Hey, please do not talk during court. Our goal is to move your case forward promptly, to return you back to your lives, and frankly, I won't have any patience with anybody who gets in the way of our efforts to return everybody else back to their lives. All right, nobody's virtual. All right, cell phones. Everybody has pet peeves in their life, slow drivers in the left lane, 21 items in the 20 item checkout, that kind of thing. So everybody pull your phones out, because that's mine, and turn them off. If they ring after this moment, it means you've ignored my request for you to turn it off and that you would like to have a contempt hearing. I don't want to have a contempt hearing, and frankly, I'm going to tell you ahead of time, you don't want to have one with me either. Let's just skip that step, turn the phones off, and let us move at full speed. It works better for y'all to do that. All right, this is the correct courtroom for you. If you were arrested for a misdemeanor here in Spalding County, you appeared or waived your arraignment date, you requested a trial, and if what I'm saying sounds incorrect, speak to the bailiff out in the hallway, show them your paperwork, and they'll get you moving in the right direction. Today is what's called your calendar call. It's where I go over your rights with you, and then I tell you what your options are, and then you or your attorneys tell me what to do with your case. You may have a trial. There are two types of trials. There's a jury trial, where 6 jurors issue a verdict in that box over there. And then there's a bench trial where you give me permission to make the guilt or innocence decision with no jury present. You may have a conference with the solicitor's office. That's this group up here to your left. And you can ask me about an attorney, and I will let you speak with this group up here to your right. All right, Veterans and Mental Health Court. Ms. Karen is here from our Veterans and Mental Health Court. If you are a member of our military, or you're a military veteran, or you have a mental health diagnosis, and you want your case dismissed, then if you're representing yourself, then you can speak with Ms. Karen. She's our accountability court representative. Or you can ask for a conference with the solicitor's office to see if you are a candidate for our accountability court. If you have an attorney, simply speak with your attorneys. They're very familiar with the program, and they can answer any questions you may have. Everyone's charges in this courtroom are misdemeanors. The average misdemeanor carries maximum punishment of 12 months to serve in the Spalding County Jail and or a $1,000 fine. A few minor traffic charges like seatbelt have a lower maximum fine, and a few high and aggravated misdemeanors have up to a $5,000 maximum fine. All right, everyone here has the right to a speedy and public jury trial, where 6 citizens of Spalding County decide guilt or innocence on each of your charges. You can also choose a bench trial. That's where I decide guilt or innocence without a jury. You can waive your right to a trial and close your case with a plea. I have no preference. You must knowingly, voluntarily, and intelligently choose for yourself. Now, you have the right to be presumed innocent. You have the right to force the state to prove your guilt beyond a reasonable doubt. You have the right to cross-examine the state's witnesses. You have the right to subpoena your own witnesses and evidence to court. You have the right to testify or not testify. You have the right not to incriminate yourself. And if you choose to remain silent, your silence cannot be held against you. You still have the right to have an attorney. You may hire your own attorney if you so choose, and there are very qualified attorneys over there in the jury box if you want to talk to one of them. However, if you cannot afford an attorney, then you should have applied on your arraignment date in the courtroom like I asked you to with the Public Defender's Office. Now, I warned you at your arraignment date that if you did not take action ASAP to secure the Public Defender's Office, you would very likely waive the right to apply for their services. But if you still want to have that conversation, I'm more than happy to have it with you. All right, an attorney would help you understand our criminal justice system, to explain what your charges are and what the defenses are of those charges. File motions on your behalf, engage in plea negotiations, subpoena witnesses and evidence for your defense, conduct a trial on your behalf and make objections, protect your record and appeal a conviction, and otherwise work to protect you. All right, I'm responsible for explaining first offender and conditional discharge. These each allow you to enter a guilty plea without being convicted. Now, you only get one of each though for your entire life. So, first offender is for everything but traffic-related charges, i.e. like no DUIs. Conditional discharges are drug-related charges only. All right, no-look contendere and traffic charges. We call this a no-look plea for short. It's where you enter a guilty plea without admitting guilt. It is available again on traffic charges, no DUIs. You get one no-look every 5 years, and that is measured from the incident date to the incident date, ticket date to ticket date. A no-look will usually prevent points. It will usually save your license. It won't help you much if you're under 21. All right, if you are here today and you are not a U.S. citizen, you need to know that any conviction will very likely have a negative impact on your immigration status. All right, family violence charges. Several of you on this calendar are charged with family violence. It's in the title of your charge. If that is you, and if you are convicted of that family violence charge, you need to know that you will lose your ability to get a Georgia weapons carry permit. And federal law will step in and say that you may never again possess either a firearm or ammunition. All right, habeas corpus. So it's my job to explain this weird old law called habeas corpus. Here's how it works for us. You may sue Spalding County civilly over in Superior Court to challenge your conviction here. All traffic charges in this courtroom have 6 months to use those rights before they expire. Everything else in this room has a 12-month window to use it before they expire. All right, we have a conference today with the solicitor's office. Again, that's this group up here to your left. If that is you and you're representing yourself, you'll simply stand up when your name is called and announce conference. The solicitor's office represents the state of Georgia. They're not your attorney. If you reach an agreement with the solicitor's office, you can resolve your case today. If you do not reach an agreement, then you must return to this courtroom for me to personally give you your next set of instructions, which will include signing the verdict form. Now, attorneys, y'all don't have to come back and see me. Just go to the solicitor's office if you're unable to resolve your case. All right. If you receive probation today, you need to know that you will be supervised by the Spalding County Sentence Enforcement Team. There will be a one-time $25 intake fee per case. 100% of all fines can be worked off with community service work at a rate of $10 per hour. There will be a $50 per month supervision fee each month until you complete your probation. This fee is mandatory, but it can certainly be waived after a separate hearing before me. All right, this is a 2-week trial calendar, and all the trials, jury and bench, are together on this trial calendar. So how this works is, this is week 1, and this is your calendar call. We all then go skip a week in the middle, do some other court while everybody gets ready for trial. And then the Monday of week 2, we will reach your case for trial. Monday of week 2, it begins Monday at 9 a.m. sharp, and we will you'll appear each and every day until your case is resolved. We'll use 2 or 3 courtrooms, probably 2 for our jury trial week, and we will reach your case for trial. All right, bench warrants are going to be issued this morning for people who failed to appear. We're still a small enough community where everybody knows somebody who knows everybody. So if you recognize the name of someone who is missing, you will do them a wonderful favor. If you call them, tell them to get down here ASAP, and you will definitely save them a great deal of future trouble. All right, pretrial motions, speedy trial demands, etc. You must let me know if you have any outstanding pretrial motions, speedy trial demands, or anything else that I need to factor into the scheduling of your case for trial. Failure to provide me this information results in waiver, as well as bench warrants results in waiver of those motions. All pretrial matters must be heard at the first scheduled calendar, or they are waived, unless I preserve them on the record in open court. All right, I went with a lot of titles for this slide, and so I just thought this is important. Might just tell you all that this is important. So here we go. If you announce jury trial or bench trial, what you're telling me is you don't want a conference, you don't want an attorney, you don't want a continuance, you don't want to enter a negotiated plea, you don't have any motions to be heard, because this is your last chance to ask for these options. I have zero intentions of exploring any of those options when I've got a jury standing outside of those double doors ready to come in and try your case. That's the whole purpose of calendar call, is to explore those options. Okay, so I'm about to call the calendar. When you hear your name called, stand up. If you're able, if you're not able to stand up, wave your hand or a line, just get my attention. Now, if you have an attorney, which there are many attorneys here today, you need to remain silent and you need to let them announce. So if you stood up, you've done all I need you to do. If you are representing yourself, however, then what you're going to do is announce one of the following on the wall, and then you're going to have a seat. So if you're representing yourself, then you're going to stand up and you yell out really loud, jury trial, or bench trial, or a conference, or attorney, and of course, are there any motions? All right, any housekeeping, Ms. Shepherd?
No.
There you go.
Let's check in.
Arrested.
Yeah, do some job.
Page 1, Paul Avery Dennis, halfway down.
followed by Vincent Lloyd Carr.
Cars, y'all's, right?
Carter's.
Yes.
And Judge, I believe there's a,
That's what it's my opinion.
yeah, that's my understanding, is that we're still waiting on the mental eval to come back from Mr.
I've
Carr.
not seen it come back.
No, Your Honor, his mother is in the courtroom today.
Okay, on car?
Yes,
All right, I'll speak with her and see if there's any questions, but I think we're just still in hold. So, okay.
So, yeah, he continues on to page 2, and page 3, bottom, Amber Nicole Hortz.
That's ours too. Judge.
That's how
That's
it's.
yours?
So she'll be on tap, I guess, for Wednesday.
Yes, so Wednesday afternoon at 1:30.
Page 6 of 8, at the bottom, Romero Rosa.
Good morning, Judge. This is my client. I've spoken with Mr. Shepherd. This is the first time on the calendar. He has some much more significant charges upstairs. And Mr. Seventh State, I'll be asking for a continuance to see if we can resolve the Spalding one first.
Okay, I'm gonna put y'all down for a conference as soon as y'all are organized. Just-
Yeah, we met when you delayed court this morning.
Yes.
We
Oh,
met
great.
on
So
it
you
already.
already
Yeah, Mr. Romero, he's got several serious felonies upstairs.
Okay,
No bonded on those. This is one of those situations where the resolution of that case is probably gonna control the resolution of this one, so
okay.
we're fine with continuing it.
So just a quick procedural question. Is he in on the felonies or is he in on
Felonies.
this? Okay, so, all right. Well, then let's do this. I'll let you sign for it. When we get finished here, just talk to Erica. Cause she can look at the felonies and kind of see where this should go. I don't need it to go on the next calendar if that's not gonna get us where we want to go.
I think we have a calendar call arraignment at the end of this month. It's a newer case, but it's gonna take a lot of work on my part to get it
Okay.
resolved.
That's all right. Well, then definitely get with Erica and y'all are welcome to put it wherever there's a consensus that it should.
Thank you, Judge.
All right, thank you. Then obviously he won't be signing for it because he's in the jail. You're okay with that?
Yes.
Okay, it's yours. Okay, who else?
That's it.
That's it for today?
Just to put you on guard, the 5th looks like the jail arraignment.
Yeah, it usually ends up. Okay, all right, let's jump in then. Curtis Adams? Curtis Adams? Yeah?
That's for a bond for return of income.
Good.
It was just here on.
All right.
We had it on the motion calendar a couple weeks ago, and he was present for that. I don't know why he didn't.
Yeah. I don't know. He's not here, actually.
No, Your Honor.
Timothy Anderson? Timothy Anderson? For over 2,
That's for bond for return of benchmark.
granted. Rodriguez Barlow?
He is ours, Judge. He had car trouble today, so we're gonna have him come in tomorrow.
Okay.
I know Patrick's gonna still make the same
Yeah.
request, but
I'll bookmark it and then that'll be fine when it gets here, so.
So that's for bond forfeiture and benchmark.
All right, that's granted. Just let me know when it gets here.
yes, Your Honor.
That way if he doesn't show, gotta come. So, all right, Paul Bennett's in jail. He's not yours. We'll see him Wednesday at 1:30. And I'm just saying again,
9
everybody,
a.m.
do what?
Wednesday, 9 a.m.
Is it 9 or 1:30?
I think we're moving that, I think that's April.
Yeah, it's
Yeah.
April 10th.
So I
Yeah, could be
couldn't,
here
I didn't
now.
move March's.
Oh.
It's April. But yes, well, that's exactly what I was about to say.
I will not go into the jail, so thank you.
Yeah. So yeah, that is exactly, you and I are saying the same thing. So let's just take a moment to communicate with everybody. Starting in April, we're swapping our Wednesday calendars. The jail calendars are going to 9 a.m. and whatever's at 9 a.m. starting in April will go to 1:30. So it's fixed a lot of logistical issues.
That's April 10th to be exact.
Okay. So, all right, so we'll see Bennett this Wednesday at 1:30. As well as Carr, you said Mom's here, if you need anything from me on that.
Yeah, we're just waiting on the ME to come back on that one. I don't believe there's much we can do.
No. I don't think there is. All right, Lakeisha Clark,
Conference.
thank you. Victoria Clark,
Conference.
all right, Mercedes Cobb,
Here. Attorney.
okay, so you have David.
That's David West case, Judge. I've been in communication with Mr. West a couple times about this. My understanding was
All right, hold on. Yeah, whoever that is, step out, please. Who was that? Come on, don't make me figure it out. Really? Okay. Well, y'all, whoever just did that is not gonna do any favors to the phone who rings next. So, no one knows whose phone rang.
No, it was on this side over here.
I have a good suspicion that I know who it is.
It was me.
Then step outside.
No, I'm saying I'm finna turn it down. I got
Step outside now. What's your name?
Carter West.
Mr. Watson, please step out of my courtroom before I have a contempt hearing with you. I'm trying to extend a courtesy. I knew it was started having this black.
So on Miss Cobb, Judge, Mr. West, is my understanding, is representing her. He had this was continued off the last trial calendar
Yes,
to come in on the 6th for a plea.
right, that's,
The last communication out of Mr. West, that he had a conflict today.
well, how about just have her come back on the 6th then?
Yeah.
All right, Miss Cobb, is that you, ma'am? Ms. Cobb, your attorney has asked for y'all to be, and this is the first I'm learning of this as well, so I'm passing this along to you. Mr. Shepherd has said he's been in contact with Mr. West, and he has asked to appear with you on the 6th, that's this Wednesday at 9 a.m. So if you want to step outside and call his office before you go, that's fine, but I just thought you should know that I'm not looking for you until this Wednesday at 9 a.m. So if you want to step outside and call his office to confirm that before you leave, you're welcome to do that. All right, Eddie Dennis. All right, he's,
He's always confidential.
thank you, Mr. Charles. Morgan Fuller.
Your Honor, that's your plea.
Okay.
She's,
Oh, I see it.
that's your plea. She has to report to the RC in party before and you're waiting for her.
All right, I'll take it before I step off the bench.
Thank you, Your Honor.
Laura Griffin.
Bench.
Good, thank you.
She hasn't acted.
Brandon Hightower. Let's see.
So Judge, Mr. Martin's office, I don't know if I got that email or not. Okay, it was just a sharing. Mr. Martin is very sick, apparently. They said he's in bed sick. His office had called last week to notify us that they had not been able to contact Mr. Hightower, and they did not anticipate him appearing today. So
Okay.
I think that would have been, I can't put words in Mr. Martin's mouth, but that's what he said last week. So,
Okay.
and I don't know that Mr. Hightower is here today. It's the second bench warrant on this case.
Yeah,
That's the reason
that's
I'm bringing
pretty,
this up.
that's a pretty simple solution, because if Martin's sick, so this, what I would do next wouldn't have anything to do with Martin being sick. So, Mr. Martin,
So we'll ask for a bond forfeiture and bench warrant.
okay, that's granted. And then obviously if Mr. Martin is able to locate his client and come in and get it resolved, then that would be fine with me, so. So we'll just make certain to communicate with Mr. Martin that the bench warrant today had nothing to do with him being sick. Okay, Amber Hortz is y'all's Wednesday at 1:30 through March, then we go to 9 in April. Brianna Johnson.
Conference, Your Honor.
Perfect, thank you. James Jones.
Ben.
Bench.
Ben.
Okay.
It's a 2020 case.
That's- Okay. Lawrence Lamar.
Conference, Your Honor.
All right, thank you, Mr. Lamar. Got you. Thank you very much. All right, Joan Martinez? Martinez? No?
That's for a bond forfeiture and a bench warrant.
Granted. Kendrickis Matthews?
That's my case, Judge. That's for the conference.
All right, thank you. Hey, I'm gonna move, Jones over for a conference. I'm backing up a couple. That, James Jones.
We put Jones. We put Jones in the conference. Sure.
Give them my confidential treatment.
Okay, Macy Moore?
No, that's our client, and we understand that Mr. Moore is in treatment in Lamar County. You know, so
I could probably fill in on that. So Judge, I spoke to the ADA from Lamar County. Mr. Moore is in their drug treatment program,
Okay.
their drug court.
oh, that's the one.
Yeah, that's
Okay.
that one. He is currently in inpatient treatment, but it's prerequisite him coming into their drug court, he had to do up to a 12-month of inpatient. He's like 2 months into it. So what I told the ADA over there we would do is just continue, and told them last week also, is just continue this, say like August or so.
And I've got a draft to share with you all today of September, October, November, December, so we
Okay.
might tentatively push out close enough to maybe get, because that'll get you all good and finished the impact, is that what I'm hearing? He's 2 months into a 12-month?
Yeah, I think it was 2 months, it may have been 3, something like that, but what I said we would do is I wasn't gonna push it out a full year because of the nature of the charges, but if he's in treatment, I wasn't gonna pull him out of treatment, so let's just do August for now.
Okay.
We already got that calendar out, right?
You okay with that? Yes.
Yeah, we'll just do August
We're out
and
through August.
And then take a look at it in August, if he's still in treatment, we'll kick it again, if not, we'll deal with it.
All right, so you'll just get with Erica, and I'm just gonna put reset. All right, Jacqueline Naraki,
Compatron.
Lester, Olivia,
Go France.
thank you. Mr. Dutton, Jake Osborne,
That's gonna be a conference as well, Your Honor.
thank you. Montez Parks. No,
That's for a bond forfeiture and bench warrant?
granted. All right, Winter Virgil Browns,
They're coming on Wednesday.
Wednesday, sounds great.
Yeah, they have Singleton and Dutton today, Virgil on Wednesday.
Okay, and then Mr. Dutton, done with his. Mr. Singleton, back to you, Reginald Smith.
You'll be a conference, Judge.
You represent him on all 3 of his cases?
I do, Your Honor.
I had you on the last one. All right, back to you, Mr. Bulloy, Adrian Taylor. Adrian Taylor, no,
That's for a bond forfeiture and bench warrant.
granted. Charles Twilly,
Present, Your Honor.
all right.
I've had a conference with the prosecutor. I'm ready to settle this today.
Okay, we'll speak with it. This is the one that I emailed you about last week, where he was starting a new job
Yes.
today, but it ended up not being today, so he just came on in. Enter his police, we'll speak with him, get the paperwork written up.
Okay, and then I have that we have a walk-in with Dutton Shepherd.
That's correct, Your Honor. Who's close?
Yeah, that was the shoplifting bench warrant.
That's correct, Your Honor.
Yeah, y'all, I thought that was a great solution, just to walk in.
Yeah, since we were so close.
Thanks.
We have a motion to lift the bench warrant on that, Your Honor. She never got notice. We have to approve.
That's fine, I'll let y'all talk.
Yeah.
All right, Edgar Vines, Mr. Moore.
Compatron.
All right, thank you. Mr. Vines is waiting to be back there. All right, Watson's out in the hallway. I'm gonna put him down for a conference.
Your Honor, just to make a note, he says he came to our office, he did, but he did not qualify for our services, so he brings that up, just let him know the answer, that's his answer.
Okay. All right, clearly he and I have many things to discuss.
Do you want to talk to him before we bring him back?
Yeah, I've got him up in the hallway right now. I'll talk to him in just a minute. And then he'll be yours. Kiana Watts.
Good morning, Your Honor. Alan Lightcap for Ms. Watts. We've worked out a pretrial intervention that's ready for Your Honor's signature.
Excellent. Y'all can, I'll sign that in just a minute.
Thank you, Your Honor.
And I don't need to formally do that. Y'all can just bring it up as soon as we finish this.
Yeah, Alan, if you would, is probation here?
They usually get here about 9:30, so they should be here about now.
If you'll get your client, probation, if you go right through those doors right there, probation is just to your left. Just take that paperwork to them, and then they'll send it over to Judge Thacker to sign when they get done with it.
You're good to go. All right, is there anyone else here represented by Mr. Dutton, or any of the private attorneys whose name was not called? Anybody else is here with the private attorneys? If you're here with one of the private attorneys, your name was not called, you're good to go. They've got your cases in hand. So,
Judge Kenneth Osborne, I'm not sure if that's on, maybe tomorrow.
yeah,
That was there.
well, and I appreciate y'all doing that. Let me see if I can find out what's going on.
I think it's on Wednesday.
Yeah, some on Tuesdays.
Was a bind up from city court.
Okay, well, I'll just let y'all have a conference.
We'll figure it out.
Figure it out. If it's not here and you can't work it out, we'll get it, y'all can get it rescheduled for it. All right, now, are there any witnesses who are subpoenaed to be here today? Any witnesses? All right, that's a no. Anyone else whose name was not called? If your name was not called, stand up for me. There's always one or two, it's okay. What's your name, nice and loud? Dutton? Say it much more louder. All right, I'm cheating because I have a microphone, so, Johnson.
She's on.
Who's ours, Judge? We said
Yeah,
conference.
Yeah. Yeah, I've got it right here. You're all in here. Thank you so much. You're good. That's a reasonable question. All right, anybody else? All right, so, let's do this. I'm going to let Mr. Shepherd and Mr. Malloy go ahead and make their announcements. And then I'm gonna take the Fuller plea while everybody gets reset. And then I'll give some instructions and stuff.
Good morning, y'all. I'm Patrick Shepherd. I'm the solicitor. That means that I'm the prosecutor. This is Jackie Tony. She's the other solicitor. We'll be the ones that do the conferences this morning. If you are represented by an attorney, there's a good many of you have an attorney. We can't speak with you directly, but we'll meet with your attorneys here in a few minutes, give them plea offers, they'll relay those to y'all. So for the rest of the morning, just follow your attorney's instructions. Those of you who do not have an attorney who have asked for a conference, what's going to happen is in a few minutes, Ms. Sherry Middleton there with a green sweater on, Ms. Lenise Fletcher over there with a black sweater on. So we can call the names. We call about 4, 5, 6 at a time. When your name is called by one of those ladies, you're going to go through the double doors over here to my right, your left. Follow them down a hallway that leads to a waiting area outside of my office. Have a seat in one of those chairs. Either myself or Miss Tony will call you back one at a time for your conference. When you're done with your conference, you're going to come back down the same hallway through the same double doors. Probably have a seat here in the courtroom to either enter your plea or get instructions for your trial in a couple of weeks. When you come back into the courtroom, make sure that you do use the double doors here. Don't use the single door over there next to Mr. Singleton. If you do that, you will disrupt court, make the judge unhappy. Not a good way to start your week. Obviously, there's a lot more of y'all than there are of us, but we know what we're doing. We move quick. We do this just about every day. We'll have everybody out here at a decent time today. All right, thank y'all.
Good morning, my name is Terrence Malloy. To my left is Mr. Harry Charles, legal two attorneys for the Duke's firm who will keep on the public defender's office. Those of you who've already examined for, some of you have been spoken to prior to today. For those of you who haven't, we have your cases in hand. We're going to meet with you individually. On the second time you're not here, you're going to have to address the court. The judge will tell you what he's going to do at that point. So just help us help you, and you try to get as fast as possible by being present here in the courtroom when we call your names. Thank you.
Your Honor, Judge Ballard's staff has called me up to the fourth floor this morning. I just need to go check in with them and then come back down.
Okay, and he's on 3.
He's on 3? Okay, so.
I just found that out, so. All right, that'll be fine. Doug's clients, just sit tight. Let's go ahead and do Fuller, and then I'm going to make my announcements and go from there. So Fuller, come on out. I think we get you in DRC. I wish we had access to the DRC.
That's the one in Clinton County.
That would be wonderful.
Yeah.
Okay, ready, everybody? All right. All right, everybody, let's come back to order. Ms. Fuller, raise your right hand for me.
Yes, sir.
You solemnly swear or affirm the testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down, state your full name for me.
Morgan Marie Fuller.
Ms. Fuller, you're here on 22 SR 1126 because, okay, you were on time for court today, is that correct?
Yes, sir.
Did you get the rights to read out to the courtroom and see the PowerPoint that I put up on the wall?
I've seen everything, sir. Yes, sir.
All right, and did you understand those rights?
Yes, sir.
All right, Clint, she missed one line right there.
Thank you, apologize.
No, it happens. Okay, I am holding up this attorney and defendant plea rights waiver that your attorneys passed up to me. Do you recognize this document
Yes, sir.
as the written version of those rights I read out earlier?
Yes, sir.
Are these your initials next to each of the lines on page 1,
Yes, sir.
page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
And because you understand to ask your attorney any questions you have about it?
I have, yes, sir.
And because you understood everything that's on it?
Yes, sir. I did.
Ms. Fuller, have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, sir. I did.
Are you satisfied with the job your attorney's done on your behalf?
Yes, sir. Very.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial, and this case will be closed? Is that what you want to do?
Yes, sir. Please.
Do you understand that you have the right to, I'm so sorry, do you have any other questions for me about anything before I pin it to the facts of your case?
No, sir.
Mr. Charles, do you stipulate that there is a sufficient factual basis for me to accept this plea for the theft by shoplifting here in Spalding County on August 31st of 2020?
Yes, I do.
Do you wish to enter a guilty plea to that charge, ma'am?
Yes, sir.
Okay. I'm going to find that between the attorney's stipulation as the factual basis combined with Ms. Fuller's request to enter a guilty plea, that there's enough for me to take this plea. I'm going to find that she's knowingly, voluntarily, and intelligently waiving her rights and entering this plea. I review the recommendation and I will follow it. Mr. Charles, anything you wish to add before I sentence?
Yes, Your Honor, she's supposed to report to DRC by 8:30, but I talked to them in Clayton County, they expecting her. And the condition is there'll be no fine, but she must stay with DRC until 2026. If not, then she'll have to report to us for probation.
Okay.
Yeah.
Um,
And the fine is zero because she cannot work while she's in the DRC.
okay, as far as so this is running concurrent to the
To the
DRC.
DRC.
Okay, well, what I've written on here is, are you currently on any misdemeanor sentences of any type?
Not misdemeanor, no, sir, I'm just on Clayton County probation,
Perfect.
DRC.
That's what I needed, so we're good. Okay, all right, any questions for me, ma'am, about anything before I sentence?
No, sir.
All right, Ms. Fuller, I'm going to follow the recommendation. The sentence of the court is as follows. Morgan Fuller on 22 SR 1126, count 1, theft by shoplifting. I'm going to find you guilty. It's 12 months probation, no fine. Let's see. There's no fine. Do you have a valid license?
Yes, sir.
All right, show that to sentence enforcement. You'll be tested, but we will probably rely on DRC, but I'll let you work out those details with sentence enforcement. They don't want to add to it, they just want to have good
With
communication.
DRC, she has to be drug tested twice a week.
Yes, so just communicate. Director Matthews is very familiar with that, and she has a good relationship with them. $50 a month supervision fee, $25 intake fee. This is consecutive to any state court,
Curtis Adams in here?
any state court sentence. $50
Curtis Adams?
public defender fee. Don't go anywhere at Walmart, and complete DRC. All right, that's the sentence of the court. You have 30 days from today. If you wish to appeal this decision, you have 12 months from today if you wish to use your habeas rights. Any questions about anything? All right, obviously, there's a video feed out right now on YouTube, so if anybody wants to know where you were at 9:48, they can see you.
Okay. She's going to see probation and then go to DRC as soon as you finish.
And Clint,
She's going to see.
will you help, will you make certain that
Yeah,
the
she is.
sentence enforcement team knows she's in a hurry? All right, you have anything else before I make?
Yes,
announcements?
Your Honor. Ms. Carr, Vincent Carr's mom,
Yes.
she would like to address the board. Ms. Carr.
Good morning, ma'am.
Good morning.
So if you'll please raise your right hand for me, do you solemnly swear or affirm the testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down and state your full name for me.
My name is Captain Michelle Bennett.
All right, Ms. Bennett?
Bennett.
Bennett. Ms. Bennett, you are Vincent Lloyd Carr's mother?
Yes, sir.
Okay, so Ms. Bennett, where we're at on your son's cases, is that he has 1, 2, 3, 4, 5, 6, 7 cases. Actually, let's just hold on just a quick second, so she can call first.
Thank you.
Go ahead.
Do you want me to wait to call Mr. Watson?
No, you can go talk. I'm just still gonna talk.
Okay. Do you mind grabbing Mr. Watson for me? If I call your name, if you'll go through these double doors, I'll meet you in the hallway. Lakeisha Clark, Recoria Clark, James Jones, Lester Oliva, Charles Twilley.
And I'm very curious as to what his demeanor will be when he is back
Back
here.
there, me too.
So y'all let me know.
Okay, I sure.
That's why I'm moving him to second, because that way I can address it if it needs to
Okay.
be addressed.
I will let you know.
Yeah, he's probably gonna go to jail. All right, Ms. Bennett, your son has what's called a mental evaluation outstanding, as you're well aware. We do not have that back, and I don't know what the time frame is to get that back. Mr. Watson, I'm holding court. He is just determined to go to jail today. What questions can I answer for you, ma'am?
Okay, you kind of summed it up. Because Vincent, he's don't have a history because we're from Florida. He's both been on medication. He's been here.
Just slow down. Don't take the mask off. Just slow down and lean into the mic, and I'll be like.
Okay. I said Vincent Carr he's chemical balance. He's disabled. So by him not being on medication, all the things that occurred, that's what he's been doing. So I asked him, he told me I'd come ask you, is it possible that you can like send him to a facility so he can get back on his med? Because he wasn't born like that. He was laced in college. And he's supposed to be on medication. He hasn't been on the medication for a minute now. He's been incarcerated 8 months. And they can't really do nothing with him in jail. He hasn't been fingerprinted or nothing yet. Because he's not, he chemically imbalanced right now.
The short answer is I hope so. We have learned here that out some of our people who are the most disruptive, who have mental health struggles. Once we can get them properly medicated and get those medications kind of tweaked in,
Yes, sir.
that they're fully functional, not fully functional, but you know what I mean? They can interact and have conversations and at least be enough to be aware. And so yes, that's our goal, is to help them. But what is that gonna look like and how are we gonna get from here to there? I don't know. We're waiting. Once we get that back, if it says he's competent, we'll have to look at it in one direction. If he says he's not competent, we have to look at another direction. And I'll go ahead and tell you that, I have said this from the bench on countless occasions, Mr. Malloy has heard me say this, that we as a court system have failed the mentally ill here in Georgia. We owe them a much higher level of care, and we owe them a much higher level of resources. And so I just want you to know we will do the best we can. But the felony cases get priority for treatment and housing. And they don't even, and they're all backed up 6 ways to Sunday. But we're very creative here and we care deeply about our people, and we will do everything we can to figure out some way to help him. I don't know what that's going to be, but I just know that I trust my team, because you may not know this yet, but I'm the luckiest judge in the state of Georgia. I've got the most amazing team of people who care in every direction. So, okay?
Yes, sir.
So we care about your son, and we're going to do, somebody get her some tissues. So we care about your son, and we are going to we're going to do everything we can to take care of him, okay?
Thank you, sir.
Okay.
Thank you.
Thank you, Ms. Bennett. Sorry to make you cry there. We're going to take care of you. Okay. All right, I'm gonna make my announcements and then I'm gonna step off the bench for a minute. Here's my announcements. You ready? I need everybody to pay attention. So one of you, statistically speaking, is going to volunteer to go to jail today. So, and it's not Mr. Watson, so I guess that's maybe 2 of you, statistically speaking, are gonna volunteer to go to jail. And let me tell you how and why. I don't know how to stop this, but what happens is whenever I take a break, statistically speaking, and I don't know if you're just trying to get your yard mowed or a haircut or what, I don't know, but somebody wanders off. After I say these instructions, you ready? They're super simple. Hey, we're all human. We've all had coffee. Step to the restroom. Get back to your seats. Like, those are the instructions. There's nothing complicated about them. We're all human. Most of us had coffee. Step to the restroom. Get back to your seats. But one of you, statistically speaking, is going to wander off and not come back. And what I'm going to do when that happens is I'm going to issue a warrant for you. I'm going to hold you in the jail without bond because you obviously can't be trusted to stay. And then I'm going to go see you in a couple weeks out of the jail. So I hope I'm wrong today, but statistically speaking, I'm not. So here's your instructions. I'm going to take a break until 10:30 because this next phase goes a lot quicker when I'm not sitting here. Your instructions are, we're all human. Most of us have had coffee. Step to the restroom. Get back to your seats. And I'll sign the warrant for whoever's not here at the end of the day. There's generally always one. All right, with that said, bailiffs, you have the floor. If you have any questions, speak with them. they're ready. No, I can't do it. One of y'all needs, please, one of y'all go wake him up.
Watson.
I think he's doing something.
I didn't check.
Hey, Judge, his mother's out in the hallway. You want her to come in?
His mother's out in the hallway.
I mean, that's fine. He just needs to wake up. Okay, so what I'm gonna do is call y'all up, work my way through y'all's cases. Looks like Mr. Jones. Mr. Jones, if you'll come have a seat at the table up here.
You got it.
Turn the mic on, please.
Right here.
Slide back to the seat.
Slide back, babe.
Thank you. Sure. We designed this exactly for that purpose. You can stay with him if you prefer.
Thank you.
So, all right, since you may end up speaking, I'm just gonna have both of you raise your right hands. You both solemnly swear or affirm the testimony you're gonna give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Wait, yes.
I do.
All right, just say your full name.
James Daniel Jones Jr.
All right, ma'am, and what's your name?
Barbara Jane Barnes.
Okay, Ms. Barnes. And I appreciate you helping Mr. Jones out today. And again, we specifically designed that exact spot for this
Yes.
exact moment.
Thank you.
For folks who come up who are unsteady on their feet or frankly just need to sit down or in a
Yes.
wheelchair or whatever. So if you have any feedback for us on any way we can make that better for you,
Okay.
please tell us, because like I said, I'm the luckiest judge in Georgia. I have amazing team members who take great care of everybody who comes through.
Thank you.
Mr. Jones, you're here on 20 SR 2058, and you were on time for court today, is that correct?
You was on time, yes. Yes.
Yes.
All right, do you have it, are you okay hearing me? Can you hear me okay?
He doesn't hear good.
Okay, hold on, I'm gonna get very loud then. If I get really close, Mr. Jones, am I loud enough for you to hear me okay?
Yes, sir.
Okay. Mr. Jones, will you say your full name for me?
James Daniel Jones Jr.
All right, and Mr. Jones, you were on time for court today. I saw you there, is that correct?
That is correct.
Did you hear what I read out and see that PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
You have passed up to me this self-represented defendant plea rights waiver that I'm holding up. Do you recognize this document?
Yes, sir.
Do you recognize it as the written version of those rights that I read out earlier?
Yes, sir.
All right. Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
And is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time you needed to review it?
Yes, sir.
And because you understood everything that's on it?
Yes, sir.
Are there any questions I can answer for you, Mr. Jones, about anything on this document? Do you have any questions for me about anything?
Yes, sir.
Okay. If you think of any, do you promise to interrupt me and ask?
Yes, sir.
Okay. Mr. Jones, do you understand that you do have the right to have an attorney represent you? Do you understand that?
Yes, sir.
And you're here representing yourself on this suspended license charge, is that right?
Yes, sir.
Is that what you want to do?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, we're not gonna have a trial, this case is gonna be closed, is that what you want to do?
Yes, sir.
Okay. Okay. Did you, no, it's a NOLO. Have you used a NOLO plea on any suspended license charges in the last 5 years?
No, sir.
Okay. And you're 21 years of age or older?
Yes, sir.
Okay, we both are. We're in this together. So, all right, Mr. Jones, do you currently have a license?
No, sir.
Are you anticipating trying to get a license?
No.
All right, then I'm going to remove the license requirement and we'll fix that. All right, that's taken care of. Okay, I can't quite give you the recommendation, the way the recommendation is written up, I can't quite give you that sentence. I'm gonna make a couple of small changes and then I'll walk through them with you. They shouldn't hurt you, but I can't quite do it the way they want to do it. I understand why they did it this way though. So give me just a second. Okay, so they have recommended that I accept your case under our 30 by 30 program where it's a payable ticket and you pay $30 and you have 30 days to pay your ticket off.
Yes.
But unfortunately, suspended license is one of 2 charges where Georgia law says I must give you probation. Do you understand that, Mr. Jones? That
Yes, sir.
So what I've done is I've modified it just a bit where it's still terminated upon completion, because I only have to give you 2 days of probation. So by the time you get to your first report date, you'll have done what you need to do, from my perspective, to close your case. So you can still close it at your first report date. Do you understand that?
Yes, sir.
Okay. All right, that'll work then. All right, so with that one change, this works great. And as I said a moment ago, I've removed the license requirement. We normally require people to get their license back. All right, Mr. Jones, are there any questions I can answer for you before I sentence?
No, sir.
You ready for me to sentence?
Yes, sir.
All right, ma'am, and you've been helping Mr. Jones. Do you have any questions for me?
No, sir.
All right. Mr. Jones, the sentence of the court is as follows. Again, I'm going to find that you're knowingly, voluntarily, and intelligently waiving your rights. I'm going to find that we've discussed all of your options fully and that you are fully aware of your choices and that you are making them knowingly, voluntarily, and intelligently. On 20 SR 2058 from February 2nd, 2019, Mr. Jones, on the suspended license charge, I'm going to grant your NOLO. It's 12 months probation and $692.50 is your fine. You may work off your fine with community service work if you wish. Count 2 is dismissed. Now, alcohol, illegal drugs, or drink products should be tested for those. I'm going to make it a little bit better as well. Our office for the sentence enforcement office, you have to go down a flight of stairs to get to it. And so what I'm going to do is I've just changed you to e-report. You should be able to get it closed.
Okay.
But if you can't, you're going to be on e-report because you getting in and out of that office is going to be very difficult.
So for page 692, I'll be on probation?
I'll give you the exact number. I don't normally do this math because I'm so terrible at math.
Me too.
And yeah, we're all, and as funny as I've got 2 kids who are really good at it.
He was great at it. This is
Yeah.
my brother.
That's why I married my wife. She's very good at this math. All right, so then 767.5.
767.
Now, if they say something slightly different, go with what they say because they're good at math.
Okay.
Okay, so the final sentence is, $50 supervision fee, that was calculated in, a $25 intake fee. This is consecutive to any current sentence. I've moved you to e-report because of your physical disabilities. And your case will close the moment you've satisfied your obligations to the court.
Thank
You have 30 days from today if you wish to appeal this decision. You have 6 months from today if you wish to use your habeas rights. Okay, any questions for me about anything, Mr. Jones, before you and I part ways?
No, sir.
All right, then you may head out those double doors, the bailiffs will give you a hand, get you back with the sentence enforcement team, and they'll take good care of you.
All right, thank you.
Mr. Jones, you take it slow, you be safe.
You got it? Yeah.
Mr. Charles, I'm at your beck and call, what can I do for you?
He's gonna fast.
Oh, no, Rocky?
Yeah, no, Dennis is with probation. He's starting off probation this is 7 days.
For like a pre-trial?
No, he's gonna be a plea. It's a DUI, but he's doing the iPad.
Got it. Is Shelton y'all's as well? It's just not. All right, is it now Rocky?
Yes, sir.
All right, please raise your right hand. You solemnly swear or affirm the testimony you're about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down, say your full name for me.
Jacqueline Brooke Naraki.
Mr. Rocky, you're here on 2 cases, 22 SR 1620 and 1621. It looks to me like looks like we're getting our plea on 1620, and I forgot to sign it. I put it up there for Clint. Clint, that's my fault. I put it up there for you to take it, didn't even sign it. Sorry. That's on something else. Sorry, Kevin. I just made an ugly transcript of a mess. Let's fix it up. All right, back with Ms. Naraki. Ms. Naraki, you were on time for court today, correct?
Yes, sir.
You heard the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand them?
Yes, sir.
Your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time you needed to review it,
Yes, sir.
and a chance to ask your attorney any questions you have about it,
Yes, sir.
and because you understood everything that's on it?
Yes, sir.
Are there any questions I can answer for you about anything on this document?
No, sir.
Have you had all the time that you need to speak with your attorney about all aspects of both of your cases?
Yes, sir.
Do you understand that, and are you satisfied with the job your attorney's done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial and this case will be closed? Is that what you want to do?
Yes, sir.
All right, so, Ms. Naraki, you are charged, okay, I need to do one more step. You're charged with 1 count of battery family violence. So I need to note for the record that by entering this plea, you understand that you will lose your, go ahead.
She lost her right to firearm already on her. She had a
Okay.
felon.
Okay, so you initialed the line that says it's not a family violence. I'm going to mark that out. So that's just very clear that you are, and that we talked about it on the record.
Yes, sir.
So you're already a convicted felon?
Yes, sir.
All right, that tells me what I need to do. All right, so, Ms. Naraki, that works. Okay, do you have any questions for me about anything before I pivot to your attorney with my next set of questions?
No, sir.
Mr. Charles, do you stipulate there's a factual basis to support this battery family violence charge from July 13th of 2022?
Yes, I do, Your Honor.
And do you wish to enter a guilty plea to that charge, ma'am?
Yes.
All right, I'm gonna
Yes,
find
sir.
between your attorney's stipulation as the factual basis and your request to enter the guilty plea, there's enough for me to take the plea. I'm gonna find that in 22 SR 1620, that you're knowingly, voluntarily, and intelligently waiving your rights in entering this plea. Review the recommendation, and I'll follow it as negotiated. Do you have any questions? Mr. Charles, the floor is yours. If you
No,
don't-
sir. Thank you very much.
Ms. Naraki, do you have any questions for me about anything?
No,
before I
sir.
send this?
No, sir.
All right, you ready?
Yes. Yes, sir.
Ms. Naraki, on 22 SR 1620, from July 13th of 2022, count 1, battery family violence, guilty, 12 months, 590 is your fine. Counts 2 and 3 are dismissed. You may work off your 5 with community service work, show your valid license to the sentence enforcement team. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver, $50 per month supervision fee, $25 intake fee. This is consecutive to any current sentence. Restitution of $50 to offset the cost of your attorney. $20, 20 hours community service work, no violent contact with Brooke Naraki, Thomas Norris, or Rebecca Naraki. And you shall have no access to firearms or ammunition,
Okay.
which was already a condition of your life.
Yes, sir.
Due to the prior death.
Right.
All right, you have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. I'm also signing the null pros on 22 SR 1621, which is null pros pursuant to plea negotiations.
Okay.
Any questions I can answer for you about anything before we part ways?
No, sir.
All right, if you will step out those double doors back there, Mr. Phillips is going to walk you out and meet with some.
Okay, thank you so much.
All right, I'm going to take a 5
He's ready for a plea. Dennis? Is this last guy? What? Good.
I think he's coming up. This is the solicitor's.
Dennis, you ready?
Look there, file.
I
Let's see if that's.
don't know, does it have the numbers on the side? I was just comparing it to those over there, is what I was looking at, to see if it was similar.
Is that y'all's file?
Which one is
The one in Kansas City?
No.
He was always late for class too, Judge.
All right. Everybody ready? Okay, so you, please raise your right hand for me. Do you solemnly swear or affirm the testimony about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God? Yes, sir. All right, everybody come, let's come to order. All right, if you'll lean in the microphone and say your full name for me.
Andrew Dennis.
All right, Mr. Dennis, you're here on two cases, 22 SR 0841 and 22 SR 2402. All right, one of the cases is going to get dismissed, that's 0841, and we're going to enter a plea on 22 SR 2402. You were on time for court today, is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom and see the PowerPoint that put up on the wall?
Yes, sir.
Did you understand those rights? Okay, you're very soft-spoken, and I've got to make a good record to protect you, so just lean into the mic, it'll get loud if you get close.
Okay.
And again, the record is not here to protect me, it's here to protect you. So, all right. Your attorney has passed up to me this attorney independent plea rights waiver. Do you recognize this document?
Yes, sir.
Do you recognize it as the written version of those rights I read out earlier?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
And because you understood what's on it?
Yes, sir.
And did you have an opportunity to ask your attorney any questions that you have about it?
Yes, sir.
Okay. Mr. Dennis, you, have you had all of the time that you need to speak with your attorney about all of your cases?
Yeah.
Okay, that was a very tentative, yeah. So do you need any time right now to speak with Mr. Charles about any of your cases before I go forward?
You have any more questions for me?
Not really.
Okay.
No, sir.
All right, so it's another tentative no. So here's what we're gonna do. I'm just gonna put on the record that I'm gonna go forward with the words that you're saying, and I'm gonna disregard your body language. So if you tell me to stop going forward, I'm gonna stop going forward. But what your body language is saying and what your words are saying are not the same thing. Do you understand that?
Yes, sir.
Okay, so I'm going forward with the words from this moment forward. Are you ready to go forward with this plea?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes.
You understand that by entering this plea, there will be no trial and this case will be closed. Is that what you want to do?
Yes, sir.
Yes? Okay. Mr. Dennis, Mr. Charles, do you stipulate that there's a factual basis for me to accept this DUI plea from May 1st, 2022 here in Spalding County?
Yes, I do, Your Honor.
Mr. Dennis, do you want to enter a guilty plea to count 1, the DUI charge?
Yes. What is it, sir?
Yes or no? I couldn't hear you.
You have to
Even
speak
with the
loud.
microphone, I
You
can't hear you.
loud.
Speak
Yes,
up,
sir.
Ed.
Yeah.
Can you repeat that again?
Do you want to enter a guilty plea to the DUI charge? Yes or no?
Yes.
I'm sorry?
Yes.
Yes. Okay. Count 2, fleeing. Mr. Charles, do you stipulate that there's factual basis to support the fleeing charge?
Yes, I do, Your Honor.
Mr. Dennis, do you want to enter a guilty plea to this count 2, fleeing and attempting to elude charge?
Yes.
Yes or no?
Yes.
Yes. Again, I'm going forward with the words coming out of his mouth, just like I said I would, but I'm stating for the record that his body language is telling me something different. If he wants me to do different, he needs to tell me so. I'm gonna find otherwise that, that his plea is knowingly, voluntarily, and intelligently entered. I'm gonna find with his admission of guilt on both charges combined with Mr. Charles' stipulations of factual basis, so there's enough for me to take the plea. I'm gonna find, that the recommendation is proper, and I will follow the recommendation as negotiated. Do you serve any time before, when you were first arrested?
Yes.
How much? Hours or days?
That's hours.
Hour, okay. The sheriff will work that out with you then. Okay, Mr. Charles, anything you wish to add?
No, just for the record, Your Honor, as I talked, this is his second intent, so that's why the fine and the community service also high.
Okay. I can see that, thank you. All right, Mr. Dennis, do you have any questions for me?
No, sir.
You ready to go forward?
Yes, sir.
Okay. Eddie Dennis on 22 SR 2402 from May 1st of 2022, count 1 DUI, guilty, 12 months probation, $2,076 is your fine. Count 2, fleeing, guilty, 12 months consecutive for a total of 24 months, $742.50 is your fine. 3 days in the Spalding County Jail, credit for time served. Counts 3, 4, and 5 are dismissed. Show your valid license to the Citizens Enforcement Team. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver, $50 per month supervision fee, $25 intake fee. This is consecutive to any Spalding County case, any state court case. $50 in restitution to Spalding County to offset the cost of your attorney. 240 hours of community service work. Substance abuse evaluation within 90 days. UI school within 60 days. And that's the sentence of the court. If 30 days from today, if you wish to appeal this decision, you have 6 months from today if you want to use your habeas rights.
And Your Honor, for the 3 days, Mr. Shepherd and I discussed that he can do a weekend for that.
Okay, I'll mark that right now. All right, so I've marked that your jail time can be served in weekends, and I'm gonna put starting, do you work weekends or anything?
No, sir.
All right, then I'm gonna put the 15th. You can sort that out with Citizens Enforcement. If it needs to be changed, I can change it. Okay, all right, Mr. Dennis, I'm signing the NALPROS on 22 SR 841. Okay, there's the one that goes with it. And so both of your cases are closed. All right, anything else? All right, you'll step out this door. What else do you need, Mr. Charles?
I don't know, Mr. Malone may have a couple of down with you up there. If he has them.
All right, Clark, Corey Clark. All right, ma'am, if you'll please raise your right hand for me. You solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down, state your full name for me.
Recorded by Keisha Clark.
And Ms. Clark, you here, looks like you got a couple of cases. Two. And you were on time for court today, is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Okay, it looks like just one of the cases is on the calendar. That's 23 SR 1919. And then we also have there's another Clark on here.
Yeah, it's another Clark.
Are those cases overlapping in any way?
No, it's just, together,
Okay.
the same case.
Okay. All right, so I'm just gonna, sorry, I thought that those cases were yours, that's all mine. Okay, now I'm back on this right page. All right, Ms. Clark, you have passed up to me the self-represented defendant pay rights waiver. Do you recognize this document?
Yes, sir.
Are these your initials next to each of the lines on page 1,
Yes, sir.
page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time you needed to review it?
Yes, sir.
And because you understood everything that's on it?
Yes, sir.
Did you see on here where it says you have the right to have an attorney represent you?
Yes, sir.
And you're here representing yourself?
Yes, sir.
Is that what you want to do?
Yes, sir.
You understand that you have the right to a jury trial?
I do.
And that by entering this plea, there will be no trial, this case will be closed? Is that what you want?
Yes, sir.
Do you have any questions I can answer for you about anything so far?
No, we went over it.
Okay. Ms. Clark, you are charged with 1 count of simple battery. It's not a family violence charge, and that you did here in Spalding County have unlawful physical contact with Cornelia Woods here in Spalding County on May 6th of 2023. Did you do that?
Yes, sir.
All right. I'm going to find with your admission of guilt as a simple battery that there's enough for me to take your plea. I'm going to find that you're knowingly, voluntarily, and intelligently waiving your rights to enter your plea. I'll review the recommendation and I'll follow it as negotiated. Do you have any questions for me before I sentence?
No, sir.
You ready?
Yes, sir.
All right, here we go. Recordia Clark on 23 SR 0919 from May 6th of 23, count 1 simple battery, guilty, 12 months, 870 is your fine. You may work off your fine with community service work. Count 2 will be dismissed.
Okay.
Show your valid license to the sentence enforcement team. No illegal drugs, alcohol, or hemp products should be tested for those. $50 per month supervision fee, $25 one-time intake fee. And your case will close once 6 months have passed, no violations have occurred, and all conditions have been met. One of those conditions is to have no contact whatsoever with Ms. Woods.
Yes, sir.
You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. Okay. Any questions for me about anything before you and I part ways?
No, sir. Thank you.
All right. Ms. Clark, if you will step with Mr. Smith out those double doors, and best of luck to you. Okay. Lakeisha Clark. Clint. She looked through it, she didn't know her niche, so she needs to sign it. Have you had a chance to look at that document yet?
I did.
Okay, we just didn't get a chance to get you to initial it. Just take the time you need and initial it, and then we'll be ready. All right, ma'am, if you'll please raise your right hand for me. You solemnly swear or affirm the testimony you have to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, take your hand down and state your full name for me.
Lakeisha Clark.
Ms. Clark, you're here on 23 SR 0918, and your case was related to Recordia Clark's case right before you, which was 23 SR 919. Ms. Clark, you are on time for court today, is that correct?
Yes, sir.
Here the rights are read out to the courtroom and see the PowerPoint that I put up on the wall.
Yes, sir.
Did you understand those rights?
Yes, sir.
You have passed up to me the self-represented defendant thin rights waiver. Do you recognize this document as the written version of those rights?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
And is that your signature?
Yes, sir.
And although you signed it pretty quickly up here, this was a document you looked over fully, you just didn't get a chance to initial.
Right.
Is that correct?
Yes, sir.
All right. Did you have all the time that you needed to review this document?
Yes, sir.
And did you understand everything that's on it?
Yes, sir.
Do you understand that you have the right to have an attorney represent you?
Yes, sir.
And you're here representing yourself?
Yes, sir.
Is that what you want to do?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial and this case will be closed? Is that what you want to do?
Yes, sir.
Are you a citizen of the United States?
Yes.
Okay, I'm gonna initial that line. You missed that one, but that's okay. I'm gonna initial it, we're gonna keep going. All right, so, did you here in Spalding County, back on May 6th of 2023, commit the offense of simple battery by having unlawful physical contact with Cornelia Woods here in Spalding County.
Yes, sir.
All right, I'm gonna find with your admission of guilt, there's enough for you to take your plea. I'm gonna find that you're knowingly, voluntarily, and intelligently waiving your rights in entering this plea. I reviewed the recommendation and I'll follow it. Do you have any questions for me about anything before I sentence?
Yes, sir.
Okay, you ready to go forward?
I'm inquiring about the,
Oh, you have a question, go ahead.
I was inquiring about the, would I qualify to use my NOLO so it won't show up on my record due to my job?
You're almost there. So if you wanted to use your first offender, I don't generally do NOLOs on non-driving offenses. If you're wanting to keep it off your record, what I would tell you is you may ask me to do a first offender. First offender is where you enter the plea, but I set the plea aside while you go and complete your probation conditions. And once you've completed them successfully, then your case will close without a finding of guilt. I will say, however, that if you do choose that pathway, I'm going to take away the terminated upon 6 months. Because that is something, if you're going to get first offender and you're going to get a clean history, I want to make certain that you've done what you're supposed to do for the 12 months.
No, I don't need it.
So, but I just want to make certain you know that I would absolutely grant that and help you keep it off your criminal history if that's what you asked me to do.
No, sir, it's fine.
Okay. All right. Well, I'm going to state on the record that you asked me about NOLO. I converted it to first offender. We walked through it and you declined it. Okay. Do you have any other questions for me?
No, sir.
Because that was a good question. So, all right, Ms. Clark. Do you have any questions before I sentence then?
No, sir.
All right, here we go. Keisha Clark on 23 SR 091A from May 6th of 2023. Count one simple battery. I'm gonna find you guilty. It's 12 months probation. 87D is your fine. 870. You may work off your fine with community service work. Count two will be dismissed. Show your valid license to the sentence enforcement team. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver, $50 per month supervision fee, $25 intake fee. Your case can close once 6 months have passed, no violations have occurred, and all conditions have been met. This is consecutive to any current sentence of probation. And you're to have no contact whatsoever with police units. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. Do you have any questions for me about anything before we have part ways?
No, sir.
Okay, and I'm gonna pass you off to Mr. Phillips. He's gonna walk you out and have you get me to the sentence enforcement team. Thank you. Thank you. Lawrence Lamar. Is that yes, Terrence. Is Mr. Lawyer ready?
Yeah, ready, sir.
Give me just a second. I may have gotten ahead of you. You want to stand in? You'll stand in? Okay.
Come on,
You can come on up. Wait, that doesn't work. You always have to decide it. Okay. I don't know if it's going to work or not, but Mr. Lamar, we've worked very hard to create a space where we can accommodate anyone of any abilities. If you need anything from me, if this doesn't work for you, you tell us and we'll adjust, okay?
Yes, sir.
All right. Does this work for you for now?
Yes, sir.
Okay. I'm going to place you under oath. Are you ready?
Yes, sir.
Do you solemnly swear or affirm the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, state your full name for me.
Lawrence Edward Lamar Jr.
All right, and Mr. Lamar, you were here on 22 SR 2340. And according to my calendar, you were on time for court today.
Yes, sir.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
Mr. Lamar, your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document?
Yes, sir.
Do you recognize it as the written version of those rights I read out earlier?
Yes, sir.
I'm missing a null process there. It's got two cases. Lamar. I don't mind finishing
Let me
this.
get the fact from Mr. Moore.
Yeah, I just don't see the other one. I just want to make certain I'm not supposed to be doing two, please. Absolutely.
Your Honor, he said he gave the dismissal with the baby.
Oh, great, okay. So, I've signed a couple and passed them down, I may have already done that. We'll work it out. All right, Mr. Lamar, we're gonna enter a plea on one case, which is 22 SR 2340. And then, what Mr. Malloy is saying is that 23 SR 0075 will be null proster dismissed as a result of this plea. Is that your understanding of what we're about to do?
Yes, sir.
Okay, well, I'll go forward with that. I don't have that document here in front of me, but I'm sure it'll show up. All right, so back to 2340. Did you have all the time that you needed to talk to your attorney about all aspects of your case, including this attorney and defendant plea rights waiver?
Yes, sir.
Are you satisfied with the job Mr. Charles and Mr. Malloy have done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial and this case will be closed? Both of your cases will be closed. Is that what you want to do?
Yes, sir.
All right, Mr. Lamar, do you have any other questions before I pivot to your attorney with my next set of questions?
No, sir.
Mr. Lamar, you're charged with one count of misdemeanor terrorist threats and that you did for events that occurred here in Spalding County on July 17th of 2021. Mr. Charles, do you stipulate the factual basis for those charges?
Yes,
Of
I
that
do.
charge, excuse me.
Yes, I do, Your Honor.
Mr. Lamar, do you want to enter a guilty plea to this terroristic threats charge from July 17th of 2021?
Yes, sir.
All right, I'm going to find with your with your request to enter a guilty plea, combined with Mr. Charles's stipulations of factual basis, there's enough for me to take the plea. I'm going to find that you're knowingly, voluntarily, and intelligently waiving your rights in entering this plea. I reviewed the recommendation, and I'll follow it as it's been negotiated. Mr. Charles, anything you wish to add?
No, Your Honor, thank you.
And Mr. Lamar, do you have any questions that I can answer for you?
No, sir. No, sir.
You ready for me to sentence?
Yes, sir.
All right, on 22 SR 2340, count one, terrorist threats, we'll find you guilty. It's 12 months probation, 445 is your fine. Counts 2, 3, and 4 are dismissed. You may work off your community service work if you wish. Do you operate a motor vehicle in any way?
No, sir.
I'm going to remove that from the, there it is. All right, now I have your second case's null process in hand. All right, I'm removing the license requirement. This is consecutive to any current sentence of $50 in restitution to Spalding County to offset the cost of your attorney. I'm going to place you on e-report immediately. Our office for the Sentence Enforcement Office is down a flight of stairs. It'll be incredibly difficult for you to get in and out. And so I'm placing you on e-report.
Yes, sir.
And they'll explain to you how that works. So, and I'm just going to put here that you're in a wheelchair. And that's the sentence of the court.
So, Sergeant, was one a reduced charge?
I don't know.
Because I've got it as a different charge.
You're right. It
I
is.
just think it's
Yeah, it's out of order.
on.
Let's see which one this one is. This, all we gotta do is read it for the charges, that's all. Just give us a second.
Yeah, 2 count of terroristic threats.
So,
Count 1 and 2.
well, they're just numbered oddly. So count 1 should be unlawful conduct of a 911 call. Count 2 is disorderly conduct.
Also, Patrick put down the wrong number?
Yeah, I think he just numbered them wrong. I think this is an easy fix, but is it, the terroristic threats is count 3 or count 4, I guess? Either one? Can I just pick one?
Okay. Pick one.
Pick one? All right, I'm gonna pick three. So, because I can easily turn a number one Roman numeral into a count three. All right, so I'm gonna put, this is terroristic threats, count three. I'm going to mark that counts 1, 2, and 4 are not processed. That's right.
The copy that we have has,
We've had a couple of these where they.
count 1 and 2 are terrorist threats, and then count 3 and 4 is unlawful 911 call and reported.
We've had a couple of these where they come down and walk in. Let's go off record. All right, let's come back on order. Okay, so the issue was that the calendar had the charges in a different order than the accusation. We sorted that out. And so we're okay now. We're gonna leave it as it is. So, Mr. Lamar, I've signed the null process on your second case, so that's dismissed. Do you have any questions for me before we part ways?
No, sir.
All right, if you will head out those double doors, Mr. Phillips is gonna walk you back there and have you go meet with the sentence enforcement team.
Thank you, sir.
Your Honor, can I approach?
Sure, come on up. Mr. Lester, raise your right hand for me. You solemnly swear or affirm the testimony you're about to give tonight will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down and state your full name for me. What is your full name?
Lester Alberto Oliva.
Okay. I think I got you backwards. So your first name is Lester?
Yes, sir.
Okay. And Alberto Olivia is your last?
Alberto is the middle name, Oliva is the last name.
Okay. Mr. Olivia, you are here today on 22 SR 1074. Am I detecting that English is your second language?
Yes, sir.
Is Spanish your first language?
Yes, sir.
Do you understand that tomorrow at 1:30 I will have, that is our interpreter calendar, do you understand that?
Yes, sir.
And I will have both a Spanish-speaking interpreter here and a Spanish-speaking attorney here to assist anyone whose English is their second language. Do you understand that?
Yes, sir.
And you could use those services at no cost to yourself if you wanted to come back tomorrow at 1:30.
But I do not have no problem with communication. The solicitor explained everything, and I'm ready to solve this case if that's possible. I've been waiting for almost 4 years now.
I know, it's just my job to have a conversation with you on the record to
Yes,
make
sir.
certain that you understand that you have access to resources that you may not know if I don't tell you.
Yes, sir. Thank you.
Okay. Well, Mr. Olivia, I'm gonna move forward then, but at any moment, if you change your mind, you just tell me to call a timeout. I will paperclip this, I will send it over here, and I will pick it up at 1:30. So if you change your mind, you tell me, okay?
Yes, sir.
All right, so you were here on time for court today, is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, sir.
Are you able to read and write in the English language?
Yes, sir.
I'm holding up this self-represented defendant plea rights waiver. Do you recognize this document?
Yes, sir.
And are these your initials next to each of the lines on page 1,
Yes, sir.
page 2?
Yes, sir.
And you put a check mark next to the box that says, I'm not a U.S. citizen. Is that where you would have put an initial?
Yes, sir.
Okay, that's fine, that's good. And did you sign and initial these documents after having all the time that you needed to review it?
Yes, sir. I did.
And because you understood everything that's on it?
Yes, sir.
You understand that you have the right to have an attorney represent you?
Yes, sir. I did.
And I've just offered you an attorney for tomorrow at 1:30. Do you understand that?
Yes, sir.
And you've chosen to go forward today, is that correct?
Yes, sir.
Mr. Olivia, do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial, and this case will be closed. Is that what you want to do?
Yes, sir.
You are charged with 1 count of driving while unlicensed. Are you asking me to accept a no-low on that charge?
Yes, sir.
Have you used a no-low plea on any driving while unlicensed in the last 5 years?
No, sir.
Are you 21 years of age or older?
Yes, sir.
And are you asking me to accept this no-load plea for driving that occurred here in Spalding County on June 6, 2021, and resulted in this charge of operating a motor vehicle while unlicensed?
Yes, sir.
Okay, so I'm gonna find that that your no-load is properly requested, and I'm gonna grant it. I'm gonna find that you are knowingly, voluntarily, and intelligently waiving your rights and entering this plea. I reviewed the recommendation, and I'll follow it. And this looks great. You have any questions for me before I sentence?
No, sir.
You ready?
Yes, sir.
Okay. All right, Mr. Olivia, on 22 SR 1074, count 1, driving while unlicensed, the no-low is granted. 12 months probation, $742.50 is your fine. You may work off your fine with community service work if you wish. Count 2 is dismissed. Are you able to get a valid license?
Yes, sir. I will.
Okay. Actually, I'm just gonna waive that. That's not, I don't know that you, I don't think it's gonna be as easy as you think it is, but I'd like for you to try. And I'm waiving that from my end. No alcohol, illegal drugs, or hemp products. $50 per month supervision fee, $25 intake fee. Your case will close once you have satisfied all your obligations and had no violations. And you were in fact fingerprinted when you originally arrested, is that correct?
Yes, sir.
Okay. Then you have 30 days from today if you wish to appeal this decision. You have 6 months from today if you wish to use your habeas rights. Are there any questions I can answer for you about anything before you and I part ways?
So you said I got 12 months probation?
Yes, but it closes as soon as you've done everything you're supposed to do. So you're only on probation as long as it takes you to do what you're supposed to do.
Okay.
Does that make sense?
Yes, sir.
Okay, that's a good question. Any other questions?
No, sir.
All right, if you'll step out in the hallway there, go to bed. All right, what else do you have, Mr. Moore?
Mr. Vines.
That Vines is, there it is. Okay. Mr. Vines, come on up. you'll please raise your right hand for me. You solemnly swear or affirm the testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down, state your full name for me. What's your full name?
Edgar Donald Vines.
All right, Mr. Vines, you're here on two cases. 21 SR 1017, which I'm about to dismiss. And then we're gonna enter a plea on 21 SR 1016. Mr. Vines, you were here on time, is that correct?
Yes, sir.
And I remember you have some memory issues, is that,
Yes, Judge.
Okay, so I'm gonna jump forward to this. This is the attorney and defendant plea rights waiver. Do you recognize this document?
I have to look at it close here.
He's got a couple memory issues, we're gonna move a little slower on this one.
Okay, I got it.
You just keep that there. Are those your initials next to each of the lines on page 1
These are your. Yes, sir.
and page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after having a chance to review it fully
Yes, sir.
and to ask your attorney any questions you have about it?
I did.
And did you understand everything that's on it?
Yes, sir.
Are there any questions I can answer for you, Mr. Vines, about anything on this document?
How long is the probation?
12 months, but we'll get to that in just a minute.
All right.
That's a good question, we're just gonna come back to that. Okay?
Yes, sir.
All right, so, and Mr. Malloy, just to be very careful on this one, since we do know there's some memory issues, are you confident that he understands what's going on here today?
Yes, Your Honor, I did ask cognitive type questions to make sure that he knew where he was, who he was talking to, or asking him even what his name was and what day of the week it was. So Judge, I told him I had to be comfortable because I could not go forward with doing this unless I felt that he was understanding. Now, he might not remember it after we're done, but
yes.
Because he was in accountability court for a while, but was not able to complete it.
Yes, I do remember that. And I remember that we were kind of waiting for a good solid day where Mr. Vines was fully here to do this. So, okay, Mr. Vines, have you had all the time you need to talk to Mr. Malloy about your cases?
Yes, sir.
Are you happy with the job he's done for you?
Yes, sir.
Do you understand that you have the right to a jury trial on both of your cases? Yes. And you understand that by entering this plea on 21 SR 1016, there will be no trial on either case, and both cases are going to be closed.
Okay.
Is that what you want me to do?
Yes, sir.
Okay. Mr. Malloy, do you stipulate that there's a factual basis for me to take this DUI plea?
Yes, Your Honor.
From July 1st, 2019?
Yes, Your Honor.
Mr. Vines, do you want to enter a guilty plea to this DUI charge that Mr. Malloy just stipulated to?
Would that help me out?
So, well, that's your decision to make.
Yeah.
It's my understanding that's what you wanted to do.
Yes, sir.
Okay. And you understand I don't have a preference on that. You're gonna do whatever you think is best for yourself. Okay. All right. Well, I'm gonna find that after asking clarifying questions, Mr. Vines has asked to enter a guilty plea. Mr. Malloy has stipulated the factual basis. And we were waiting for a day like this to do this plea. So I'm gonna find that he is knowingly, voluntarily, and intelligently waiving his rights and entering this plea. I reviewed the recommendation and I'll follow it. Mr. Malloy, the floor is yours.
Your Honor, I think the court has a good recollection of what we've done in the past. Like I said, Mr. Vines, we attempted to get him into accountability court. He could not make that. He does have the help of 3 beautiful ladies in the back there who've been with him throughout most of this, and there was another gentleman who couldn't be present today. So he does have some support, and they are doing it out of the kindness of their heart. So I really appreciate him. I want to put that on the record and let the court know that he does have some support. But now it's up to Mr. Vines. And I explained to him that he's on probation, and his big thing is drinking. He knows if he has anything to do with alcohol, I told him he's going to be back up in the jail and there will be no questions asked. And if I see him again, I'm going to throw my hands up like, what you want me to do now?
Yeah. I mean, that's the thing. We very much wanted you to finish the accountability court. I know you tried, Mr. Vines. I just know you're not capable of finishing that. We really want you to finish this round, okay?
Yes, sir.
All right. All right. The sentence of the court then as follows. Edgar Vines on 21 SR 1016. Count 1 DUI, I'm gonna find you guilty. It's 12 months probation, 1976 is your fine. That's a total of 12 months. Count 2 is dismissed. That's 30 days of jail. I believe you served that already.
The state did agree to make that time served, so yes, sir.
Okay. So he served all that. I'm initialing time served on the 30 days. Is he still operating a motor vehicle at all?
No, Your Honor.
Okay, I'm removing the license requirement. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver. $50 per month supervision fee, $25 intake fee. This is consecutive to any current sentence. $50 in restitution to Spalding County to offset the cost of your attorney. 240 hours of community service work, substance abuse evaluation, DUI school, and you're to have no access to firearms or ammunition.
Your Honor, that was part of the first case, the one you know price, so that's why we put that on.
Okay. I appreciate that. You probably saw my face.
Yes, sir. That was one of the, that was part of the content of the first case that we're dealing with. He did have some weapons, but those are now been removed from his presence.
Okay.
But I did tell him that during the course of this sentence, he cannot have those weapons. But
Right.
once the sentence is over and he completes everything successfully, then it's potentially he get his weapons back. Also, Your Honor, as far as, because he has limited income, he asked, the question was asked about, the monthly probationary fee. I said, that's not something that can be waived immediately, but it could come back before the court if necessary. And I said I'd leave that up to him in probation.
Yeah, they have a really good system for that. They'll ask you for some paperwork, you'll give it to them, they'll review it. If they determine that you don't need to pay it, they'll actually send me an order. I haven't had a hearing on that in a long time, so it's a good system. So just do what they tell you to do and you'll be fine. So, all right, anything else?
No.
That's the court. Mr. Vines, if you'll step out to the hallway with Mr. Phillips. Yeah, here you go, Fred. All right, Mr. Matthews, please raise your right hand for me. You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, sir?
Yes, sir.
All right, take your hand now, state your full name for me.
Dricus Antoine Matthews.
All right, Mr. Matthews, you are here today on 22 SR 0990, and according to my calendar, you were on time for court, is that correct?
Yes, sir.
Did you hear the rights and read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No.
Mr. Matthews, your attorney, Mr. Singleton, has passed up to me this attorney and defendant fee rights waiver. Do you recognize this document?
Yes, sir.
Do you recognize that the written version of those rights are read out earlier?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time you needed to review it?
Yes, sir.
And asking your attorney any questions that you have about it?
Yes, sir.
All right. And Mr. Matthews, are there any questions I can answer for you about anything on this document?
No, sir.
Mr. Matthews, have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, sir.
Are you satisfied with the job your attorney's done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial, and this case will be closed. Is that what you want to do?
Yes, sir.
Okay. Do you have any questions for me about anything before I pivot to your attorney with my next set of questions?
No, sir.
Mr. Singleton, do you stipulate there's a factual basis? Oh, it's a no-low plea. Are you 21 years of age or older?
Yes, sir.
Have you used a no-low? I think these are two moving violations. I'm not sure I can do a no-low on both.
Yeah, I was hesitant. I said I didn't have a
Yeah,
problem
it's
with
worth the discussion.
And Judge, the hit and run, it was two parked vehicles, so the hit and run statute didn't apply there.
Right.
Mr. Singleton and I sat and looked at it, but it's two moving violations. With it being the same swoop, you may be able to do it.
I mean, I don't mind granting it, but I think it's more likely than not that one of them will get kicked back as a guilty plea. It doesn't come back, but it'll just get entered as a guilty.
And he'll get points assessed to his license.
I think you'd be better using it on the duty to report.
Yeah, I think, I don't remember what the points are on that one. It's 3 points. They're both serious. So, okay, well, if you want to try both, I'll give it to you, but I'm reasonably certain one of them is going to be entered as a guilty plea. They're the same points either way.
Well, Judge, he did take and complete a defensive driving course prior to appearing here in court and after the citation. I believe 1613 2A allows the court at its discretion, if he's done that, to assess no points.
You can do NOLA for one and then a 0 points for the other.
Yeah, that's what I was gonna say, yeah.
And I have that certificate here, Judge.
Yes.
I see it, we're good. Okay, well then I'm gonna move the duty to report an accident to the NOLA. I'm moving the failure to maintain lane to a guilty plea. That'll clean that up. And then, before you get out of here, we'll, get a 0 points order typed up and signed.
Thank you, Judge.
And I will close that loop. Okay. All right, here we go. So then, back to the NOLA as to count 2. Do you stipulate, Mr. Singleton, to the extent of a NOLA requirement that there is a factual basis to support the duty to report an accident charge?
There is, Your Honor.
And do you wish to enter a NOLA to count 2, duty to report an accident, Mr. Matthews?
Yes, sir.
All right, moving on to count 4. Failure to maintain lane, do you stipulate the factual basis for a guilty plea on that charge?
I do, Your Honor.
And do you wish to enter a guilty plea to that charge, Mr. Matthews?
Yes, sir.
All right, that's count 4. All right, I'm gonna find that, as to count 2, the NOLA is proper and I'm gonna grant it. As to count 4, the failure to maintain lane is guilty, and I'm gonna grant that. I'm gonna find that you're knowingly, voluntarily, and intelligently waiving your rights and entering this plea. I'll read the recommendation, I'll follow it. Mr. Singleton, anything else you want to add?
Yes, Your Honor. He just wanted to make the court aware that he does receive mail here, but he rents an apartment on the north side of Atlanta. And then he works out of town with his job. And he's already told that to probation, but we wanted to ask that if he could do the mail-in report or email report if possible.
Got it. Okay, what else?
That's it, Your Honor.
Okay. All right, you ready?
Yes, sir.
Any questions?
No.
You ready?
Yes, sir.
Here we go. Kadrius Matthews, 22 SR 0990, count 2. Duty to report an accident. The NOLO is granted 12 months probation, 742.50 is your fine. Count 4, failure to maintain lane, guilty, 12 months, 303 is your fine. Counts 1, 3, and 4. No, 1, 3, and 5.
Sorry, I was jumping around.
No, it's okay.
Well, what I originally wrote was I was gonna do the duty to report, and I realized, oh, that's count 2.
Yes.
So it's 2 and,
It's 2 and 4 that he pled to.
2 and 4, and then just no process 1, 3, and 5.
Okay, got it. Roman numerals, yeah.
I don't know why
We
you.
should do a standing order banning them. So, okay, 1, 3, and 5 are dismissed. You may work off your funding community service work. No alcohol, illegal drugs, or products, shooting without license, license enforcement, $50 per month supervision fee, $25 intake fee. This is consecutive to any current sentence. I've moved you to e-report after orientation. Your case will close once 3 months have passed, no violations have occurred, and all conditions have been met. I'm going to put a 0 points order as granted. Mr. Singleton, your office will simply email me a 0 points order.
Yes, sir.
Ms. Clark has a version of it that we've already worked out, attached the defensive driving course to it. I will e-sign it and get it filed.
Thank you, Your Honor.
All right, that's it. You have 30 days from today. If you wish to appeal this decision, you have 6 months if you want to use your ambulance rights.
Thank you, Your Honor.
Thank you. All right, I only have one case left. If anybody has anything else, I have Twilly, Charles Twilly.
Judge, on Reginald Smith, we have another offer. We're
Okay.
trying to resolve this.
Well, I'll take Twilly's plea while you're talking to him. Okay, you're Charles Twilly?
Yes, sir.
All right, please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, take your hand down, state your full name for me.
Charles Elliott Twilly.
All right, Mr. Twilly, you're here on 23 SR 1001, and according to my calendar, you were on time for court today, is that correct?
Yes, sir.
Do you hear the rights I read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes, sir.
Do you understand those rights?
Yes, sir.
You have passed up to me this self-represented defendant pay rights waiver. Do you recognize this document?
I do.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time you needed to review it?
Yes, sir.
Because you understood everything that's on it?
Correct.
Did you see on here where it says you have the right to have an attorney represent you?
Yes, sir.
And you're here representing yourself?
Correct.
Is that what you want to do?
Yes, sir.
You understand that you have the right to a jury trial?
Correct.
And that by entering this plea, there will be no trial, and this case will be closed. Is that what you want to do?
Yes, sir.
All right, Mr. Twilly, you're charged with 1 count of disorderly conduct, and that you did here in Spalding County, back on June 7th of 2023, acting in a disorderly manner, in a manner that threatened the immediate breach of peace. Did you do that?
Sir, I plead no load.
You can do it as a best interest of those two.
Yeah, happy to do that. Okay, I'm not gonna do a no load, but I'll do a best interest. It gets you the same thing. It lets you finish the plea without admitting that you actually did it.
Thanks, sir.
So it's just a different path to the same. So,
It's just a pretrial.
all right, so I'm gonna ask you a different question. You're charged with disorderly conduct. Do you wish to enter this guilty plea, not because you wish to admit the underlying facts, but because you believe that this recommendation is the best option for you after considering a jury trial, a bench trial, and your other ways to resolve the case?
That's correct. Yes, sir.
Then I'll accept this as a best interest plea. Mr. Twilly, do you have any questions before I sentence?
Not at this time, sir.
All right, I'm gonna find that you're knowingly, voluntarily, and intelligently waiving your rights and entering this plea. Review the recommendation and I'll follow it. The sentence of the court is as follows. 23 SR 1001, count 1, disorderly conduct, best interest plea is granted. Is guilty, 12 months, 590 is your fine. You may work off your fine with community service work. Show your valid license, sentence enforcement, no alcohol, illegal drugs, and hemp products should be tested for those. $50 per month supervision fee, $25 intake fee, consecutive to any current sentence. You may go to e-report immediately. Your case can close the moment you've satisfied your obligations to the court, which includes 20 hours of community service work and anger management.
And Judge, he's completed those.
Wonderful.
Mr. Twilly has been very proactive in this case, reaching out to my office about that. So that's why you have the plea offer that you have. He's already shown me proof. He's completed his community service at Dawson Trails, and he's done his anger management counseling. So all he really has left is paying the fine. I believe he had the fine ready to pay today, but I told him just because the way we're set up, he'll have to do that. But he's starting a new job out of state, so that's why it's set up as an e-report. So
Yes.
basically all he'll have to do is just provide the documentation and fine money to probation, in this case.
Yeah, this looks great. Mr. Twilly, we're grateful for your efforts to get your stuff lined up. I wish everybody did that.
Thank you, sir.
All right, Mr. Twilly, you have any questions for the Park Race?
No, sir.
All right, you have 30 days to appeal this decision and 12 months from today for misuse your agency rights. If you'll head back that way, you should be able to get your case closed and your first report taken. I tell you what, since Mr. Singleton's not part of the calendar call, let's just go off record and call it calendar call. And I'll let us do two things at the same time.